Hi guys, and welcome back to Contract B. This week is week 8, and week 8 we have the last in our 3-part series on discharge of a contract. And this week we are looking at frustration. So let's get back to the Prezi. And here we are, and let's have a look at the issue of frustration. So as I said, last in our 3-part series, week 6 we did discharge by performance and agreement. Last week we did discharge by termination, and now we are looking at discharge for frustration. Okay, now the first thing I want to say to you guys with discharge for frustration is that there's really no crystal ball test. There's no bright line test you can apply here. It's a doctrine like, most other doctrines that are intended to serve as guidelines. You can't say that there's going to be a hard and fast rule and all of these cases will fall on this side and all of those cases will fall on that side of this bright line. It just doesn't work that way. It really is very much a kind of a touchy-feely thing. You really have to look at all of the circumstances, the contract terms, and try and kind of work things out. That's why I've got the picture of a piece of string there. It's kind of like how long is a piece of string, There are guidelines, like I said, but at the end of the day, each particular case will be a case unto itself. The main guideline that we have in terms of working out whether a contract has been frustrated is the test from Cadelpha Constructions, and you may well have in Contract A in your reading of Cadelpha already come across this particular test, but it's pretty easy peasy and it's a pretty handy, rule of thumb to bring with you when you are looking at cases of frustration. So it goes without default of either party, so no one's got to be at fault. A contractual obligation becomes incapable of being performed. And why is it incapable of being performed? Because the circumstances in which performance is called for render it a thing radically different to the kind of promise that was undertaken at the time of contracting. So that might be, hopefully, ringing bells of non-est factum and radical difference. So it really has to be something quite different of its nature than what was originally promised. And we call that the change in obligation test. Obviously, as I said, facts, is how long is a piece of string? Every case is a case unto itself. What you find the commentators doing is frolicking around in the case law and grouping like cases with like cases. I mean, it's what us lawyerly, logical minds do. And so often you have these nice little what I call bookend cases that show you, well, in this kind of a scenario, on this kind of an issue, if it's this kind of a factual matrix, it'll be frustrated. If it's that kind of factual matrix, well, maybe no frustration. And the best you can really do is kind of work out where your particular facts fall on that continuum of the case law that's been grouped into that particular area. So first off, we'll have a look at destruction and unavailability. So here we have contracts that have happily been formed, but there's been some supervening event that actually destroys the whole subject matter of the contract or otherwise makes it unavailable. And the classic case here is Taylor and Caldwell, a good 19th century case, about 1850s odd. And you had a person hiring a hall in order to perform some concerts. Now, before the time of the concerts, the entire hall was burned down. And in those circumstances, obviously, to perform some concerts in the middle of a pile of ashes would be a radically different thing. There would be a changed obligation there that made performance really impossible. So, obviously, contract discharged for frustration. And we have Austin and Sheldon. We'll do land in a little bit more detail later. Just one more example of land type cases. Contract for sale of land, and then the land gets compulsorily acquired by the government. Obviously, the land is no longer available to satisfy performance in that particular contract, and the contract's going to be frustrated without fault of either party, but nevertheless, the land's still no longer available. Temporary unavailability, though, won't probably get you across the line. In the F.A. Tamplin case, we had a steamship relatively lengthy contract there, short-term requisition in terms of the government's requirements during wartime, didn't frustrate the contract. So you're getting a kind of feel for things. This will lie on that side of the line and therefore the contract will be frustrated, but if it's going to be something temporary, there's still quite a bit of time left to run on the contract, then it may not frustrate the contract itself. Then we have death or incapacity. Death is a fairly obvious one, obviously. But incapacity has some grey areas there. What happens if, for example, one of the parties gets sent to jail? In the Shep and Jerome case, we had an apprentice plumber that had been contracted to a particular firm. He got into a bikie fight and was brought to justice there. The sentence was going to be somewhere between 6 months and I think 2 years, odd yes. Upon release, the reformed apprentice plumber said, please take me back to the firm. I want to finish my apprenticeship. And they said, no, the contract was frustrated. And the court agreed with the employer there. Also, we have internment cases like Horlock and Beale, where instead of being placed in jail, the party is placed in an internment camp. So here we had the sailor being placed in a German internment camp and then subsequently claiming wages, and his employer said, no, sorry, unfortunately your contract with us was frustrated when the Germans placed you in the internment camp, and the court agreed there. With illness, a little bit more of a grey area also, so you need to consider the facts, which way things are going to push a court, the nature and probable duration of illness. So it will depend if the claimant comes to court after the illness has occurred and is claiming back pay, or whether the employer perhaps has claimed that the contract has been frustrated in anticipation of a very lengthy period of illness or incapacity by the other party there. So you need to consider things like, your duration of the illness and the terms and the nature of the contract. Was the contract something that had to be performed in a timely fashion or rather urgent, or was the contract something that could be, cooking along quite nicely and there's just this rather short period of illness or incapacity there? And then you have the cases that can be grouped around the rough heading failure of basis. And if a particular event forms the whole substance, really, of the contract, the whole basis, if the event doesn't occur, then you might find that the contract has been frustrated. And here we have a case called Crellin Henry, which was in the 1920s. It should ring bells, actually, because we've covered a case very, very similar to this in relation to common mistake. Both cases, in fact, there were quite a number of cases all flooding in around this particular time due to the illness of Edward VII and the cancellation of the coronation procession and the various different festivities that were going to happen around the issue of the coronation. And remember, in Griffith and Brymer, we had the hire of a flat for viewing of the procession. That contract had been made just a very short time after Edward's illness had been confirmed and the procession cancelled and so forth. And so because it occurred prior to the contract, it fell under the rubric of common mistake. But in Crellin Henry, where you have the supervening event being the cancellation of festivities, then of course it's going to fall under the rubric of frustration. A good little reminder, I guess, of the ways that contract can actually come to the aid of parties where things have gone wrong. So common mistake, where the event has happened pre-formation of the contract, and frustration coming in to save the day if the supervening event destroys the basis of the contract after the contract has been made. So then we have the Herne Bay Steamboat case. Sometimes students get a little confused with this one, but I don't think it's terribly complicated. We had a charter party of a ship, and you'll get rather sick of all the charter party cases that you read about this week because they seem to fill the bulk of the frustration doctrine case law. But we had a charter party again arranged around the time of the coronation of the king there, and the charter party was arranged so that the ship could sail around the naval fleet and view the naval fleet, and also view this particular naval review that the Navy ships were going to put on for King Edward's coronation. When all of that was cancelled, obviously the hirers wanted to have the contract discharged for frustration. However, the court said no, it wasn't just hired. The ship wasn't just hired to view the naval review. It was also hired to cruise around the fleet, and cruise around the fleet you can certainly do because they are all still assembled there. There's no problem with that part of the contract, and so no frustration there. Cadelpha Constructions, I won't take too much time going through it. Obviously you've done a lot of work on Cadelpha in Contract A. Nevertheless, again there, you'll recall that this was a job to construct the tunnel for the New South Wales government, and there was a lot of blasting and terribly noisy and vibration related work that had to happen there. The original contract contemplated 3 shifts a day, 7 days a week. After the neighbours got very annoyed and complained, took out an injunction that neither of the contractual parties expected could ever happen. It was restricted to 2 shifts a day, 6 days a week. And that was the basis that the contract could only be performed. And on that basis, given that it was rather radically different to the 3 shifts a day, 7 day per week routine, that contract was frustrated. So that's failure of the basis of a contract. Delay, well, here we have kind of the quintessential how long is a piece of string kind of question. Once delay shades into making performance radically different than was originally contemplated, then you may be sailing in the realms of frustration. But until that time, the parties really have to adopt, as the text says, a kind of wait and see attitude to what's going to happen to the contract. You might find that someone puts their hand up and cries frustration either before the delay has happened, in anticipation of the delay happening, or they may do so after the delay has occurred. And so, as we say here, you're going to be looking at things either prospectively or looking at things in hindsight. If you're looking prospectively, then you're going to have to consider things like the probable length of the delay that has been anticipated and how much time you've got left to run on the contract. So here we have the case of Courtline and Danton Russell, another charter party case, another wartime case. We had a charter party where a ship was meant to go up 750 miles up the Yangtze River and return. It made the trip up, and then war between China and Japan broke out, and the river was blocked. Now, at that time, it was uncertain how long the blockage was going to last for, the vagaries of war. However, a short time after the river was blocked, the river was breached, and the ship was able to get through the breach in the blockade and get back to the port it was meant to return to within time. Now, the charter party was actually held frustrated because you had to assess the supervening event, that delaying event, as at the time it occurred. And because it occurred in the throes of war and no one really knew whether that blockage in the river was going to be breached or not, then it was actually held that the contract had been frustrated at that time by that event. So that gives you a little bit of a heads up in relation to delay. Illegality. We have a couple of neon sign cases here, which I'm sure will remain with you for years to come. But it seems like an odd little thing to hire, but there you go, a neon sign. Who knew? In Scanlon's New Neon, we had the lease of this neon sign. World War II broke out, and the government prohibited the illumination of neon signs. The question there was the hiring contract frustrated because of the supervening illegality of illuminating the sign, which was what it was meant to do. And the court said no, because the sign actually still had some advertising value even when it wasn't illuminated. So because there was no radical difference really in the way that the sign was going to operate, then no frustration there. Also, in terms of supervening illegality, you have the situation where you have contracts that are either made with the enemy or with a person that's in enemy territory. They're going to be frustrated. Also, your contract is going to be frustrated because of supervening illegality if it would otherwise provide assistance to the enemy or hinder the prosecution of war. So, a fairly sensible little group of cases there. Then we have the situation of land, and land can be a little surprising because sometimes the plaintiff that is left without the buildings or improvements on their land has no remedy, and it can be a little surprising at first, but the doctrine of frustration really only applies in fairly rare situations in relation to contracts for the sale of land or contracts for the lease of land. And for sale of land, what happens here when you sign on the dotted line to buy a property, usually it will be a property being land and the improvements on the land, so a building or a house or some kind of dwelling. When you do sign on the dotted line, you get an equitable interest in the land, and that equitable interest gets converted to a legal interest once the conveyance of the land is registered on title. Nevertheless, you still have a perfectly good equitable interest prior to the time that the conveyance is registered. Because you have this fairly strong equitable interest once you've signed on the dotted line as purchaser, then the law takes the view that you really should be looking after your own interests from that point onwards. So the purchaser is considered to take the risk of something happening to the land or improvements, usually, after the time of signing on the dotted line. It's only if there's going to be a really radical change, something that would make performance very, very different to what was originally contemplated, that the doctrine of frustration will step in to destroy that equitable interest and say that the contract has been discharged. So things like if the land has been resumed, like the case we were talking about just a moment ago, or if there's been some kind of landslide and the whole lot's wound up in the sea. These are the kinds of radical difference that are required in order to frustrate a contract for the sale of land. Mere destruction of buildings is going to be at the purchaser's risk. And with leases, we also need to look at what's happened equitably and what's happened legally. Where you've agreed to grant a lease, then the other party has an equitable interest in the land. Where you've actually gone ahead and granted a lease, then you're going to confer a legal interest to the lessee. Normally that will have to be stamped and registered on title. There has been some debate in the case law as to whether the doctrine of frustration applies to leases. There was a nasty little High Court case that kind of cast some doubt on the issue. Nevertheless, it seems that the way that English authority is going, and we're probably going to follow, is that the doctrine of frustration does apply to contracts for the lease of land. However, much like contracts for the sale of land, it's going to be in very, very rare situations only that the doctrine of frustration will actually go ahead and discharge a lease agreement. So there, in one of the English cases, they said if there was a vast convulsion of nature that swallowed up the property or buried it in the sea, and that made it radically different, then frustration's going to step in and destroy the contract. But again, you've got to really think about the duration of the lease, time left to run, and the nature and object of the lease. So in Robertson Wilson, just a nice little example here, we had a tenant refusing to leave a property. The property had been declared uninhabitable, And because of that supervening illegality destroying the basis of the lease agreement there, obviously the tenant had no basis on which to continue to stay in the property. That agreement, the tenancy arrangement, had been frustrated by the property being declared uninhabitable. In National Carriers and Panalpina, it gives you a nice little bookend kind of case to the Robertson case, where you've got a longer term lease there. It was about 10 years for a warehouse, and you had access to the premises being interrupted for about 20 months. The court said, oh, really, 10 years, an interruption of 20 odd months, you still had about 3 odd years left to run on the lease, not frustrated there. So it gives you a good idea of the kind of things that the court will throw up in terms of looking at whether or not they should declare the contract frustrated. And that's about as good a place as any to leave it here for a bit of a break, and we'll come back in part 2 to look at the limits on frustration. So I'll see you soon.